I'm Doug Wiley with Police Magazine. I'm here with my good friend Missy O'Lan once again. Thank you for joining us. You very recently had a California Supreme Court decision. Of course, you defend law enforcement officers in addition to training them and giving them the tools they need to be able to articulate what they've done and why. But this court case was very significant because it addressed one of the major things that we're looking at nationwide is police pursuit policies and lawsuits stemming from pursuits that maybe didn't go exactly as planned. Tell us about the Gardena case. It was, I think, 2015, and
Yes.
only 3 years it made it to the Supreme Court. Tell us about it.
So actually in February of 2015, I rolled out on an incident where officers had been in pursuit of individuals who had committed an armed robbery, kind of a foolish armed robbery. It's kind of difficult to commit a felony in the state of California. And this one is, they pointed a shotgun at a couple and said, "Give me your cell phone, a piece of plastic that we can either deactivate right away or we can use to track you." It's like, gee, and that wasn't in Gardena, that was elsewhere. But the suspect vehicle was located in Gardena, and Officer Mike Wynn, who happens to be a driving instructor for the City of Gardena Police Department, was the primary vehicle in pursuit.
Mm-hmm.
So during this attempt to apprehend these individuals, the pickup truck headed towards the off-ramp of a major freeway, which would have been deadly.
Yeah.
And Officer Wynn did a intervention, as in it was at speed, and the vehicle struck I believe it was a light post. And after it struck the light post, the two suspects were in the vehicle. Shotgun was in in between the passenger's legs. Shotgun didn't go off. The vehicle caught on fire as they were getting the driver out, and then the passenger, and subsequently the passenger died. The family brought a lawsuit against the city of Gardena with regard to this dangerous pursuit, so to speak.
Mm-hmm.
So the legal issue was whether or not the city had immunity under the Vehicle Code section in California 1704.7. And the precedent at the time, Morgan versus Beaumont, was a case that said we couldn't win.
Mm-hmm.
Okay, because the Court of Appeal, there was a decision by the time the case was filed and that we were in litigation that in the Morgan matter that said unless the city had 100% compliance with this certification and attestation that the officers had received, read and understood their policy, otherwise known as promulgation.
And they have to sign off.
Right. And you have to show those records 100% for compliance on the day of the incident. Well, when the case came in and we looked at it and we knew we weren't going to be able to establish 100% compliance, everybody told me, "Missy, you're just going to need to settle this case because you're not going to achieve the result you want, and you're not going to get immunity for the city under this other case." And I said, "That's bad law.
Yeah.
That cannot stand,
Right.
because there's no way." See, Doug, here's what's critical to understand in evaluating this outcome. The Vehicle Code provision was put in place to encourage departments to do that training, to put in place policies and to review those policies and make sure officers understood. What's required in those policies is very detailed.
Yeah.
Most pursuit policies nowadays are 22 pages long, for God's sake.
Yeah.
And that's because there's all this detail that's required to be in the policy. So as a result, we get this case. They tell me, "Missy, you can't win. You shouldn't even try. You're going to be wasting your client's money." I called then Chief Ed Medrano, the City of Gardena Police Department. And I said, "Hey, Ed, I want to spend your money. We need to fight this. It's bad precedent." And that's what we did.
Mm-hmm.
And so we won at the Court of Appeal, and we won at the California Supreme Court last Monday.
Yeah.
And it was a 7-0 outcome. The opinion was 7-0. That's
unusual.
Yeah,
That's
very cool.
Unprecedented, actually.
Now, what does this mean? It means that departments have to have a policy in place that complies with the requirements of the Vehicle Code provision, and they have to require officers review their policy on an annual basis and sign off. Now, the department having that requirement in place, they have to make good faith efforts to make sure there's compliance. But one officer, look at the size of LAPD or LA Sheriff's Department, the California Highway Patrol, for example. Having 100% compliance, that's worth millions of dollars in immunity. The California Supreme Court agreed with us that
It's
that would
a practical impossibility.
Right, and it would negate the value of that statute.
Right.
There would be no incentive for departments to put these policies in place and require, review of their policies and understanding and compliance. There would just be no incentive, because you could have an officer that was out on, military deployment or family medical leave or anything.
Yeah.
So we're really happy we could bring that result in. We had some amicus briefs that were done by some other law firms, and we appreciate their contribution. The battle was, willing to step onto the battlefield and fight this battle, because we were told you can't win, you're going to lose, you're wasting money, and you should just get out of this.
And by 7-0, you won.
Yes.
Congratulations. Really, really great work that you've done and will continue to do to help law enforcement officers in training, safety, and have real successful careers, which is really what it's all about.
Yes.
Thank you so much, Missy.
Thank you.
Doug Wiley, Police Magazine.